Good morning, guys. My name is Shiven Asthana. I am a second year law student from WIPS IB Delhi and an intern at LEXIS and Company. So, today I'll be talking about the topic Quasi Judicial and Judicial Acts. So, the actions taken and discretion exercised by public, administrative agencies, or bodies that are obliged to investigate or ascertain the facts and draw conclusions from them as the foundation for official actions. As a general rule, only court of law has the authority to decide controversies that affect individual rights. One major exception to this rule is the power of an administrative agency to make decisions concerning the rights of parties. An administrative agency is a body of government created by a legislature and charged with supervision and regulation of a particular area of governmental concern. So, the part of the regulatory power given to the administrative agency is the power of adjudication. Under the Administrative Procedure Act, an agency engages in adjudication when it follows a process for the formulation of an order. With the exception of rulemaking, any decision by an agency that has a legal effect is a quasi-judicial action. Complaints against administrative agency often rise when an agent denies benefits or places restrictions on an individual. For example, a homeowner who seeks to build another structure on her property must obtain approval from a number of administrative agencies. If the local conservation agencies refuse to issue a permit for the building of a new structure, the homeowner may appeal this decision in a hearing before the agency's administrative board. The board may hear testimony and examine evidence at the hearing, and then it will decide whether to issue the permit or uphold the agency's refusal. Quasi-judicial activity is limited to the issues that concern the particular administrative agency. For example, the Social Security Administration may resolve disputes on issues concerning social security contribution and benefits, but it may not decide any other issues, even those related to social security benefits such as tax, estate, and probate questions. An administrative agency must hold a formal hearing only when required by the statute. A formal hearing is a complete hearing when the presentation of testimony, evidence, arguments. So, an informal hearing usually is a simple meeting and discussion between an agent of the agency and the individual affected by the agency's action. As a general rule, the scope of hearing depends on the importance of the right at issue. If the Internal Revenue Service attempts to take away a person's homestead, for example, a full hearing would be required. By contrast, when an agent of the Department of Safety issues a small fine for illegal parking, the agency needs to provide only a brief one-to-one meeting with the hearing officer regarding the issuance of the fine. Quasi-judicial action by an administrative agency may be appealed to a court of law. With a few exceptions, a plaintiff generally must exhaust all remedies available through an agency before appealing. One notable exception is that a person may appeal directly to a court of law and bypass the quasi-judicial activity of an administrative agency if the agency's remedy would be inadequate. For instance, if the creditors of a failed bank are suing the Federal Savings and Loan Insurance Corporation, they need not to go through the agency's hearing before filing suit in a court of law because the agency has adverse interest to the creditors. So, how is it different from judicial? There are some key differences between judicial and quasi-judicial bodies, in that judicial decisions are bound by precedent in common law, whereas quasi-judicial decisions usually are not so bound. In the absence of precedent in common law, judicial decisions may create new law, whereas quasi-judicial decisions must be based on conclusions of existing law. Quasi-judicial bodies need not follow strict judicial rules of evidence and procedure. Quasi-judicial bodies must hold formal hearings only if mandated to do so under their governing laws and regulations. Parental and there are also several kinds of authority in a way, but a quasi-judicial body may be both a party in a matter and also issue a decision thereon of summary force or restraint, which are the necessities of the society required to exercise by private person, and such persons are protected in the exercise thereof. They act with good faith and in a reasonable and moderate manner. Parental authority is the most obvious and universal instance. It is needless to say that any more of this here, except that modern civilization has considerably diminished the latitude of what judges are likely to think reasonable and moderate correction. Persons having the lawful custody of a lunatic and those acting by the decision are justified in using such reasonable and moderate restraint as is necessary to prevent the lunatic form from doing any mischief activity. This may be regarded as a quasi-paternal power, but I conceive the person entrusted with it is bound to use more diligence in informing himself what treatment is proper than a parent is bound. A century ago, lunatics were beaten, confined in dark rooms, and the like, and were treated very badly. Such treatments could not be justified now, though then it would have been unjust to hold the keeper criminally or civilly liable for not having more than current wisdom of experts. In the case of a drunken man or deprived of self-control, one man who is deprived of self-control by a fit or other accident, the use of moderate restraint, as well as is for own benefit to prevent from doing mischief to others, may in the same way be justified. So this was the basic difference from difference of quasi-judicial and judicial activities. Thank you.